Okay. Everyone, sorry for the technical issues. If you joined us and you just saw me looking at the screen, doing things a little bit differently with some new software. Um, anyway, my guest today, I'm very excited to have this conversation. I've been bugging her for a while now. There's Liza Goitein. She is the Senior Director of the Brennan Center's Liberty and National Security Program. And Liza is perhaps the foremost expert on the history of emergency powers, how they have been used and abused in the past, and how they're being used right now in the Trump administration. And I see this as a follow-up conversation to the excellent talk we had with Damon Linker, who went through some of the intellectual godfathers of the current Trump movement, where he really emphasized the interest and almost obsession with some of the thinkers that are very influential these days with the national populist movement in the United States, with executive power and especially executive power used in emergency situations. So this is a sort of um, part two to that conversation. Liza, thank you so much for doing this, and I apologize for the little tech issues we had getting this ready.
No worries at all. It's my pleasure to be here.
Um, let's start, Liza, with you've testified in Congress on this issue. You have been talking about it for quite a long time. Start with just the basics. Let's sort of just ignore some of the current issues, but what are emergency powers and why do we have them? I think when you get into the details, it will actually surprise a lot of viewers and listeners, some of these details.
Yeah. So the reason that we have emergency powers is inherent in the definition of the word emergency. Emergencies are sudden, unexpected, unforeseen events or circumstances that pose an immediate danger, so they require immediate action. Because emergencies are unexpected and unforeseen, Congress cannot act in advance to provide authorities that are tailored to the circumstances of whatever the emergency might be. And because Congress is, a deliberative, bicameral body, it's not really well suited to act with the kind of speed or flexibility that it might need to respond once the emergency happens. So emergency powers give the president extraordinary legal leeway, extraordinary authorities to deal with situations that Congress could not have foreseen and cannot act quickly or flexibly enough to address after the fact. Now, you'll notice that I keep talking about Congress.
Hmm.
In most countries around the world, the constitutions themselves give the president extraordinary powers during emergencies. They have entire separate regimes for emergency rule. The US Constitution is an outlier.
Is
It
there an
doesn't give the
example?
president
Is there
any,
a
yeah.
is there a prominent example in a democratic country that you're thinking
Well,
of?
there are plenty of examples in democratic countries that have ceased to become democratic or that have slid toward authoritarianism. And that is something that we have seen prominently in European and Asian countries sort of in recent history. So it is, and I would say that almost every constitution does have these kinds of provisions in them. So any country that you have seen that has been operating by emergency rule is doing so pursuant to provisions in the Constitution. And that's very different from what we have in this country, where there are, in fact, provisions in the Constitution that look sort of like emergency powers, but they're given to Congress and not to the president. A particularly relevant example right now is that the Constitution gives to Congress and not the president the authority to suspend habeas corpus in times of rebellion or invasion. So that's a really, really important distinction. Another important feature of emergency powers that again is inherent in the definition of what an emergency is that they're not intended to address long-standing problems, no matter how serious those problems might be. Again, that has to do with the proper role of Congress and the proper role of the president. If Congress is institutionally capable of addressing the situation, for example, if Congress has had ample time to weigh in on a problem and has chosen not to address it or has chosen to act in a way that's different from what the president might want to do, that is not an appropriate use of emergency powers in that circumstance. So once you understand the reason for emergency powers and the role they play in our constitutional system with the separation of powers, it's easier to spot what is an appropriate use and an abuse of emergency powers.
So can you take us through the history of emergency powers and the
Yeah.
effort in the 20th century to sort of consolidate and list
Yeah.
and reform some of these powers? Because I think that conversation helps bring us to the current
Yeah.
moment, and also we can
Sure.
talk about how recent presidents have thought about these powers.
Yeah, so from the beginning, from the founding, Congress has granted the president powers that the president will need to deal with emergencies, whether it's economic crises, military crises, labor crises. But the system we have today where the president declares a national emergency and that declaration then unlocks powers that are sort of standby authorities included in a bunch of other different laws, that system really evolved around World War I. So we've had that system in place for about 100 years. But for several decades, there was no overarching statute that governed this system, and it got a little out of hand. There was no limit on how long emergency declarations could remain in place. There was no transparency, no congressional oversight. And so in 1976, Congress passed the National Emergencies Act to try to sort of impose some order on this and provide for congressional oversight and accountability. And that is the main statutory framework that we have today, or the most far-reaching one for emergency powers. And again, the president declares a national emergency that unlocks powers included in 150 different provisions of law at this time.
All right,
All of which, yeah,
let's dwell on that for a second, because so am I right about this, that over time, I mean, the reason they sort of tried to reform these powers was over time there was just a hodgepodge of laws passed that included some kind of emergency powers, and that basically we kind of lost track of it all. Is that
yeah.
is
Yeah,
that
we lost track of the powers and we lost track of the number of emergency declarations that were in place. So what happened in the 1970s is that there was a sort of existential reckoning over executive power after revelations of, after Watergate, after revelations of CIA spying on Americans, the bombing of Cambodia. And so Congress really took a good hard look at executive power across a lot of different areas. And one of those areas was emergency powers. So there was a special committee that was formed to look at that. And they found that there were 4 very clearly obsolete states of emergency that were still in effect, including
that
President
were
Roosevelt's.
that were in effect on the books, that the president had declared, that just
Yeah,
nobody had thought
yes.
to undeclare?
Right. The president had not terminated them or withdrawn them, so they were just still there. So President Roosevelt's bank holiday emergency from 1933 was still in place in the 1970s. Maybe more troublingly, the National Emergency Declaration for the Korean War was still in place and was being used essentially to help to prosecute the war in Vietnam. So that was the kind of thing, excuse me, that the committee discovered. And of course, they were also very concerned by this proliferation of emergency powers and some of the really extraordinary authorities that they granted to the president that were worrisome on their face, and there was no, like I said, no congressional oversight, sort of no ready way for Congress to end these emergencies or prevent or respond to overreach by the president.
Theoretically, the bank holiday emergency, if a president, knowing that that was still a declared emergency on the books, um, what powers did that give, a Kennedy or a Nixon, or decades after it was declared?
Well, I mean, they give the president powers that wouldn't necessarily be relevant to today's circumstances. I mean, that's part of the problem. And I'm not able to give you a full sense of what the president could do with the powers that were then in effect as a result of this particular bank holiday. But you're touching on one of the problems, which is that these emergency declarations, and the law, the National Emergencies Act, even now, even though that law was passed to try to rein in presidential uses of emergency powers, does not, there's no requirement that the powers invoked relate to the nature of the emergency. And so any national emergency declaration that remains in place, in theory, unlocks all of the powers that are available, even if they're facially irrelevant to the circumstances at hand. And we are reliant on essentially political constraints, norms, potential blowback, opposition by Congress, those sorts of sort of softer constraints to prevent presidents from just exploiting the full range of emergency powers through a single national emergency declaration.
All right, so let's get into the details here. What are some of the emergency powers that Congress has given the
Yeah,
president?
so again, if I could just back up though, because we're kind of going ahead now to some of the powers under the National Emergencies Act, but I just want to
Yeah,
make clear
please.
national emergencies are only one type of statutory emergency power. There are other laws that Congress has passed. There are several laws that provide kind of self-contained emergency frameworks for particular types of emergencies. So there is, for example, the Stafford Act, which is used primarily for natural disasters. There's the Public Health Service Act for public health emergencies. And then there are a number of laws that, excuse me, that I refer to as pseudo emergency powers because they don't actually require an emergency declaration, but they provide extraordinary authorities that are clearly meant for extraordinary circumstances. And the best example of that I can give you is the Insurrection Act, which is the law that gives the president broad powers to deploy federal armed forces to quell civil unrest or to execute the law. So, as I said, the National Emergencies Act is the governing statute for the broadest, most far-reaching set of emergency powers, but there are other ones on the books, including ones that are of concern in the moment that we are in.
The Insurrection Act being, I mean, in my conversation with Damon Linker, where we touched on some of this stuff, this is the one that freaks out a lot of commentators in the current circumstances, and we can get to that, a little later in the conversation. But do you want to go through the specific powers that
Yeah.
the president can enjoy? Because I think this stuff just, I think, boggles the mind, especially for people who haven't really been introduced to this subject.
Yeah, I think that's right. So if you look at these 150 powers that become available in a national emergency, actually a lot of them seem pretty reasonable. And you can sort of see how they would come in handy. They don't necessarily seem to be subject to abuse in other situations. However, there are several that really do seem like the stuff of authoritarian regimes. One of the ones that I find the scariest is a provision of the Communications Act dating from 1942 that gives the president the power in a national emergency to take over or shut down radio communications facilities. And then if the president proclaims a threat of war, which is really just as simple as saying, I think there's a threat of war, he or she can go further and can take over or shut down wire communications facilities. That was last invoked during World War II, when wire communications meant telephone calls and telegrams. And most American households actually didn't even have a telephone. Today, it could arguably be used to assert control over US-based internet traffic. There's another power. It's the International Emergency Economic Powers Act, IEPA. We've heard
We're
a lot
familiar
about
with
that
that
recently
one.
because
Yeah.
right, yeah, rings a bell. So what that law does is it gives the president the power to declare a national emergency to deal with any unusual and extraordinary threat to the national security, foreign policy, or economy of the United States. And at that point, the president can basically freeze any asset, excuse me, or block any financial transaction under US jurisdiction in order to try to address that threat. This law has mostly been used to impose economic sanctions on hostile foreign actors. So it forms the basis for our sanctions regimes against places like Iran, North Korea, Venezuela. But it is not limited to that. And, on its face, it can be used against Americans whom the government determines, on its own, are contributing in some way to a foreign or partially foreign threat. At which point, the president can make it illegal for anyone to rent that American an apartment, give them a job, or even sell them groceries. So this is a pretty extraordinary power. And then, of course, there's the Insurrection Act, which doesn't fall within the National Emergencies Act, but is really one of the most concerning because, deploying the military domestically to engage with US citizens is something that is inherently extremely dangerous to a democracy. And that's why it is ordinarily prohibited. It's prohibited by something called the Posse Comitatus Act. That act embodies a really long-standing, hundreds of years old tradition in Anglo-American law. But there are exceptions to the Posse Comitatus Act, and Insurrection Act is the biggest exception. And even though it's very clear, from the history of the law and just from what it allows, that it was meant for really extreme circumstances where there was an urgent threat to public safety, to people's constitutional rights, and civilian law enforcement either couldn't or wouldn't deal with the situation. Even though that was the clear purpose, the law itself is written in these vague, broad, archaic terms that don't provide a lot of clear constraints on
All
the
right.
president's use of military. Yeah.
There's a lot to unpack in what you just said. So I want to just pause and go through a few of these because some of this stuff it just deserves a few, a little bit more explanation. To start with, I think the ability of the president to take over all communication, I don't want to sound alarmist, but what you just explained is that it's really not very hard for a president of the United States to declare an emergency and take over all wire communications in the United States. Just explain that the one more time what the predicate for that would be.
So the
Um,
predicate is that the president declares a threat of war. That's all it says in the statute. And frankly, the threat of war, even the national emergency declaration has more process involved, which is not a whole lot of process. National emergency declaration has to be in an executive order. It has to be published in the Federal Register, transmitted to Congress. It then triggers some, oversight and reporting requirements. Threat of war, the president just has to proclaim that there is a threat of war. And
there-
then that opens up this possibility of taking over or shutting down wire communications facilities. Now, as I said, this is a very old law. It was passed at a time, excuse me, when and it was meant to essentially make sure that the lines of communication were available
right. No,
for critical military communications
yeah,
during wartime,
you
right?
could understand the reason.
Yeah.
You can understand the reasoning behind it, especially as you point out when this wasn't going to affect most Americans who didn't have phones at home anyway.
Yeah, and we don't have that situation now where or not really, where if too many people are on the phone, then the wire has no more room on it physically, right? It's just a very different world in terms of technology and a very different impact to actually invoke this power. Now, we do have a First Amendment, and we have some robust First Amendment case law to protect, to make sure that power, to put limits on the use of a power like this, but then you have to ask the question in a situation where the president proclaims a threat of war, where he claims to be targeting foreign threats, right? And threats coming from people who themselves do not have First Amendment rights. In a situation where the courts are going to be inclined to be extremely deferential to the president, there is some potential, I think, for some very expansive readings of executive power that could really intrude on some of the First Amendment rights that we tend to take for granted.
And there's no congressional review of this declaration of a threat of war that would unlock these powers.
No,
Um, and there would be judicial review, presumably.
presumably.
But as you
Right,
point,
presumably. And but what we have seen, even recently in some of the cases concerning the Alien Enemies Act, is that courts are very, very reluctant to weigh in on questions like, is there a threat of war?
right.
So you're likely to see a lot of deference to the president on that point. And then the question would be, what actions are authorized? Is he in fact authorized to take over wire communications facilities in the way that he does? There are some sort of arcane legal points about whether or not, if it's something that is already within the power of the government to regulate or not, in terms of the types of actions that are taken. It's I don't want to get too weedsy on that. There is, I said for a reason that it is would arguably allow the president to take control over US-based internet traffic, and there are some very technical reasons why there might be arguments otherwise.
Yeah.
And the courts would weigh in presumably on those, and then also would weigh in on the First Amendment issue. So I mean, I don't want to be too alarmist. I don't want to say this is a completely blank check. The president says threat of war, and all of our internet communications, the entire internet within the United States belongs to the president. It's not that simple. There absolutely would be judicial review. But on its face, this law gives the president extremely broad and scary powers. And we would be entirely reliant on Congress and the courts to stand up and assert themselves in response.
You talked about how this is an old law, um, but we've already seen this president, as you pointed out, invoke and aggressively use the AEA, the Alien Enemies Act, which is a 18th century law. You don't really see those invoked very often
Not that
in
many of them,
in my, there's not that many of them. There wasn't much, the country wasn't around that long.
not a lot
Um,
of laws.
so I know you want to be cautious about predicting things, but when you saw the AEA being invoked, I mean, one of the things we've learned about the Trump administration is that there's a lot of stuff on the books that if you search hard enough for it as a president, you can you can use powers that previous presidents didn't use, perhaps because the political blowback would have been too much, or just their own self-restraint. That we're only 100 plus days in. Self-restraint has not been a hallmark of this administration. When you saw the AEA being invoked, and knowing you're the expert on this issue, how much did it, just to be colloquial, how much did it freak you out?
Well, I wouldn't say it surprised us. There's a reason that we came out with a report on the Alien Enemies Act in 2024. Trump has a way of talking a lot about the things that he wants to do. And if you pay attention, it gives you a pretty good roadmap in some cases. And that was a law that he kept name dropping. So we did a deep dive into the Alien Enemies Act, and produced a report in October of 2024. Wasn't surprised when he did it.
Hmm.
Um, but it is objectively something that should freak out anyone. This is an antiquated law that it was last invoked in World War II, and we have come to regret it. And when I say we, I guess that doesn't include President Trump, but as a nation, after the law was last used in World War II to implement the internment of um, more than 30,000 non-US citizens of Japanese, Italian, and German descent. So it's actually a separate authority from the authority that was used to imprison and incarcerate Japanese Americans. So that's an important distinction. But Congress has passed resolutions and laws apologizing for this use of the Alien Enemies Act, compensating people. Presidents have talked about how this was wrong.
Yeah.
Congress has weighed whether or not the Alien Enemies Act should even continue to exist. And that's because this is a law that allows the summary detention and deportation of people based entirely on their ancestry, based entirely on the country in which they were born, even if they are no longer citizens of that country or the country in which they are citizens, not any kind of, misconduct or any kind of evidence of disloyalty or anything like that. And under our modern understandings of equal protection and due process, understandings that have really crystallized since World War II, this is something that is arguably unconstitutional, but at least goes against some of the values that we hold in modern society. And so this was a law that should have been buried. It should have been confined to the ashes of history. It should have been repealed. And instead, here was a president dusting it off and using it to try to deport people without due process. He didn't entirely succeed in that, but certainly to deport people without any sort of evidence of the wrongdoing that he was claiming that they were guilty of.
Liza, and one of the what I was hinting at with the whether you were freaked out or not, is obviously the justification that he used in invoking the AEA is pretty close to what you're talking about here with these other emergency powers that can be invoked by just citing a threat of war. The language in the AEA is quite similar. Did that, is the, am I right about that? That the relationship is, it's just a sort of stone's throw away in terms of the language, and that arguably um, the president has essentially said there's a threat of war. I mean, he's saying that the Venezuelan government is controlling this criminal gang in the United States, and put aside from the
Yeah,
fact whether that's actually true, which the intelligence community says it's not. Um, how close are those two arguments?
well, in some ways, threat of war is broader. In some ways, it's narrower. It is narrower in the sense that President Trump is not saying that he is not saying there is a declared war with Venezuela or that there is a war with Venezuela. The Trump administration in court defined the terms of the Alien Enemies Act. The criteria are that there has to be either a declared war or an invasion or a predatory incursion by a foreign government or nation. So President Trump said there was an invasion and a predatory incursion by Tren de Aragua. In court, the government has argued that basically an invasion means somebody comes here and we don't want them, or something incredibly broad like that. The courts have not agreed with that. There's only really a couple of courts that have looked at that substantive question so far. But at the same time, the courts that have ruled on what invasion or at least what predatory incursion means have unfortunately ignored some of the really key legislative history of the Alien Enemies Act that makes it very clear that the members who passed this law considered both of those terms,
Hmm.
invasion and predatory incursion, to encompass acts of war, even if there wasn't a declared war actually happening. And unfortunately, the courts that have looked at the Alien Enemies Act, and again, we really only have a couple of rulings so far, have defined predatory incursion more broadly, not nearly as broadly as the government has defined it, but they've defined it in such a way that it doesn't actually require an act of war. And so in that sense, it's narrower than the threat of war provision in the Communications Act. However, the fact that it need only be a threat of war That's obviously broader than the current situation where President Trump is saying there is an actual invasion, not just a threat of invasion.
In the Communications Act case, how much does what the courts have you know done so far with respect to the AEA and any other litigation so far in this broadly in the realm of emergency powers? What lessons so far have you taken from these rulings? And I know it's probably a mixed bag, but
Yeah.
what does it tell you about a future in which some of these other powers we're discussing are invoked?
Yeah, well, it's really early days so far. So again, really just a couple of rulings from the district courts on this question of whether or not there's an invasion or a predatory incursion. So I wouldn't want to extrapolate any trends. I will say that in the decisions that have come out, including a decision from a Texas district court judge holding that the criteria for a predatory incursion and invasion had not been met. Um, Both of those cases, in my view, give too much deference to the factual determination of a president as to whether the actions on the ground actually meet the criteria. So what's happened is that the courts have been willing to define the criteria of what does constitute a predatory incursion or invasion, what that conduct would have to look like. But then if the president says that conduct is happening, the courts are essentially saying we're just going to defer to what the president says. Ordinarily, that kind of deference in this context, arguably is something you would expect to see because this kind of factual determination is what courts have often referred to as a political question,
Yeah.
which means it is a question that needs to be answered by the president or Congress, not by the courts. However, the political question doctrine has its limits that the courts have recognized and the Supreme Court has recognized that even in a situation where the political question doctrine might otherwise apply, the courts can weigh in if the president has made an obvious mistake, if the president has acted in a way that's manifestly unauthorized by law, if the president has exceeded a permitted range of honest judgment. And those are some of the words that have come out of the court opinions. In this situation, the president, just to give one example, President Trump is saying that this gang is sort of intertwined with, and in fact is acting at the direction of the Maduro regime. There have now been two reports by the president's own intelligence community finding the opposite, concluding the opposite. 17 out of 18 elements of the intelligence community agree that, in fact, Trento Aragua is not controlled by, is not affiliated with, is not intertwined with the Venezuelan government. Only the FBI has dissented. So this strikes me as one of those situations where courts really need to take advantage or avail themselves of some of these safety valves within the political question doctrine to say, okay, this is an obvious mistake. This is really acting in a way, this is the president acting in a way that's manifestly unauthorized by law.
I don't know if you saw the news today, Liza, but the two top officials at the National Intelligence Council, which is underneath the Office of the Director of National Intelligence, Tulsi Gabbard, she has fired two officials, and the reporting that I've seen is that it's directly related to what you were just talking about, that the National Intelligence Council put out these two reports. One report which became public through a FOIA request, a declassified version, that directly undermined the president's argument with respect to the Alien Enemies Act. Um,
And that is yet further evidence that the president is exceeding a permitted range of honest judgment. The president is not responding to the facts on the ground. The president is trying to find people who will give him the facts that he wants to hear.
yeah,
And that is
yeah.
a type of conduct that should really cause courts to set aside the deference that they would otherwise maybe afford.
Well, that's an interesting question. Is that, I mean, if you were a plaintiff in one of these cases, is that something that the courts would, or I mean, you say they should, is that is that something that if a plaintiff brought, evidence that they brought into the case, judges would have no problem pointing to the to those firings and saying, well, yeah, this is politicized intelligence, or are the courts just so deferential on these national security questions that they wouldn't say, say one way or another whether that would affect their opinion?
Right, so this is extremely rare, what we're talking about. I mean, these backstops on the political question doctrine have been articulated by the courts, but we haven't really seen them applied because we haven't had presidents who have acted with that kind of bad faith or who have gone so far beyond what the law sort of manifestly authorizes or acted in a way that's manifestly unauthorized. And so so we are in uncharted territory because we just haven't had presidents acting with this sort of disregard for the law historically, at least not in a sustained way. And I think maybe if these things were one-offs, I think maybe the courts would be inclined to blink a little bit rather than to establish precedent, establish a new precedent of withholding deference in these situations. But that's not where we are, right? There is now a concerted effort to undermine or to ignore the constraints provided in the law and to exceed the bounds of the law. We've seen it in case after case after case. And so it is hard to predict how the courts are going to respond to that. But I don't think, let me put it this way, I don't think we can look at how courts have responded in the past as an indicator of how they will respond now.
Fair. All right, let's talk a little bit more about tariffs, because I think it surprises some people to learn, and this is where I think the press has really fallen down on the job in covering this tariffs debate, because I think it will surprise people to learn that the president might not have this authority at all, and there's a whole contingent of well-credentialed former judges and academics and legal scholars who believe that what Trump did with these insanely high tariffs is not legally justified and unconstitutional. Um, Break that down for us. I know your organization is part of an amicus brief on the main case here. So just sort of start with the law itself and how to interpret it. And in your view, does the tariffs regime completely expand the authority of the law?
Sure. So these tariffs were imposed under IEEPA, the International Emergency Economic Powers Act. That is a law, one of the 150 different provisions of law that becomes available to the president when he declares a national emergency. So first off, there has to be a national emergency. And then, as I mentioned, IEEPA has a further requirement that there has to be an unusual and extraordinary threat to the national security, foreign policy, or economy of the United States. And so just to start with, right, the notion that there is a sudden unforeseen circumstance going on here, that's what an emergency is by definition.
Unforeseen
When President,
circumstance. So that's what that's what the law
right,
says. Okay.
right. When President Trump in his order referred to this trade imbalance that he's responding to as a structural problem. And certainly when you look at the trade deficit our country has run, I mean, certainly not with every country, right? But the trade deficits as a percentage of GDP were worse 20 years ago than they were now. So this is an issue, whether or not you call it a problem, that has stretched back many, many years, and that is not even at a sort of some kind of nadir. Then there's the question of this being an unusual and extraordinary threat. And the very fact that Trump has imposed tariffs or sought to impose tariffs, some of them are now paused, but on every country in the world, including countries that are inhabited only by wildlife, sort of by definition, sort of a threat that's coming from every country in the world is not an unusual or extraordinary threat. And then there's the question of
Wait, just to
whether,
pause. What's the country that's only inhabited by wildlife that we've imposed tariffs
oh, it's
on?
these islands. I'm forgetting the name of the islands, but there are islands that are inhabited mostly by penguins, I think.
I'd not heard about this. Okay. So the
Yeah.
so if the
And
penguins trade with
not to
us,
mention that, yeah, not to mention that I checked this and I think I'm right about this. I think we run a trade surplus, I think with most countries. And if it's not most, it is dozens of
Yeah.
countries, but we are also imposing tariffs on them.
Which raises the question.
Um,
Your point of saying that is raises the question of where's the emergency here? Where's anything that's new?
Correct. So, but again, those are the kinds of questions, whether there's an emergency, whether there's an unusual and extraordinary threat. Those are the kinds of questions that courts have said are political questions that they are
Mhm.
going to be very reluctant to weigh in on. Now, again, there are exceptions. There are supposed to be exceptions in cases where presidents exceed a permitted range of honest judgment, where they have made an obvious mistake. So I think this would be a good example of that. But even if
Yeah.
courts are not willing to sort of look at those questions, courts can and do look at whether the president's actions are authorized by the specific emergency powers that he invokes. So the question of whether tariffs are authorized by IEPA is a question the courts are reviewing right now, and that will presumably, go up on appeal.
So,
And
can you tell us a little bit more about that case? What court has jurisdiction over this issue and where the
Well, that's the issue right now.
yeah.
That's the issue right now because cases have been filed in different places. But in cases where they've been filed in regular federal courts, the government has filed motions to transfer the cases to the Court of International Trade. And the Court of International Trade has exclusive jurisdiction over cases involving laws that provide for tariffs. So in the context of trying to figure out whether these cases should be transferred or not, that issue has come to the fore, whether IEPA actually authorizes tariffs or not. And excuse me,
Why does the government want to direct these cases to that court? Why is that a more favorable jurisdiction for them?
I think that because based on the history of the court and the judges currently on the bench, it feels like a more favorable forum for them.
Got it. And if the plaintiffs ha-
I think that is well,
if the
I
plaintiffs had
again
their way,
that is the most likely explanation.
and if the
Sorry,
plaintiffs had their way, what
sorry, I
would
was talking over here.
no, it's okay.
Yeah.
If the plaintiffs had their way, what
They would bring the cases. Yeah, they would bring the cases in regular federal courts. And frankly, there are so many issues arising from these cases that have nothing to do with whether IEPA authorizes tariffs, and it doesn't make any sense for the Court of International Trade to be looking at questions like whether there's an unusual or extraordinary threat, or whether there's actually an emergency, what the NEA, National Emergencies Act, means. So there's a good reason to want these cases to go forward in the regular federal
right.
courts.
And it sounds
What
like this
we
is a court
argued
that
in our
deals with, sorry to interrupt, but it sounds like what you're saying is the argument here is that this is a court that resolves much more technical issues related to trade rather than such a, core constitutional issue as to, as to whether the president has this power at all.
Well, I wouldn't even call it technical versus core. I would talk about it as issues relating to trade versus issues not relating to trade. And the question of whether there is currently a national emergency for purposes of invoking IEPA is not a question about trade.
Got it.
So, and whether IEPA, whether IEPA authorizes tariffs is a threshold question that to some degree needs to be answered before the case is transferred, or at least needs to be delved into before the case is transferred. So IEPA authorizes a long list of actions that the president can take. It doesn't mention tariffs. The word tariffs isn't there, duties, taxes, none of that is there. And so the question is, did Congress sort of implicitly authorize tariffs through other terms? And the term that the government has seized on is the term regulate. Does the term regulate include the ability to impose tariffs? And the plaintiffs have a lot of arguments, including statutory interpretation, textual arguments, legislative history. We filed an amicus brief to make a little bit of a different point, which is that the legislative history of the National Emergencies Act and IEPA show that Congress was very concerned about reining in presidential power. And one of the reasons that they didn't define national emergency was because they were afraid to accidentally expand presidential power beyond whatever criteria or limits were contained in the specific emergency powers invoked. So they were very intent on those limitations and criteria in the individual emergency powers serving as a meaningful constraint on presidential action. What that means is that the government should not be reading powers into IEPA that Congress did not expressly provide. The government is absolutely correct that IEPA provides very, very broad powers. That is all the more reason not to expand those broad powers beyond the ones that were textually committed to the president by Congress. So that is the point that we have made in our brief.
Got it. And just this really frustrates me with the coverage because so much of this is contested, and I just from the moment Trump started talking about tariffs, so much of the coverage just took it as as factual that he had this power. So anyway, putting that aside, what did they point to? What's the best argument on the on the White House's side that that tariffs are, despite the fact that the word tariffs the word tariff is not in the law, that he has this authority? And can they point to previous presidents exercising this authority, even though it wasn't as massively disruptive and well, didn't have the same economic consequences as what he's proposed?
So I think their point is that the term regulate is imprecise and vague and very general, and therefore it doesn't necessarily foreclose a reading that would encompass tariffs.
Did previous
But
president have previous presidents?
let me just say quickly,
Yeah.
so the question is to the extent that there's any kind of ambiguity about what regulate could encompass and couldn't encompass, do you weigh in on the side of giving the president more expansive authority, or is the default the opposite, that really if Congress meant to give the president such a sweeping power, it would have and should have said so explicitly.
Got it.
And so, yeah.
And that's the point that you
So
guys have made in your brief.
we've made it, and the plaintiffs made it as well. Now, they weren't necessarily talking about the purpose of IEPA and the National Emergencies Act in terms of reining in presidential emergency powers. They were relying on the major questions doctrine, which is a doctrine that has really emerged in recent years as sort of a leading interpretive tool that the Supreme Court uses. And that is, if the president takes any action that has major economic or political significance, then the courts will look to make sure that Congress clearly authorized that action.
Yeah.
Um,
And if
so,
viewers wanted some more about that, my conversation with Michael Ludig last week, we talked quite a bit about the history of that doctrine. Um,
yeah, so you
so
asked whether no
yeah,
president has previously used IEPA to impose tariffs in almost 50 years, which on its own is extremely strong evidence that IEPA wasn't intended for that purpose. President Nixon used a predecessor statute to IEPA called the Trading with the Enemies Act. There was language in the Trading with the Enemies Act that was then imported into IEPA, and President Nixon relied on that. Well, President Nixon imposed tariffs for a brief period of time. He actually didn't rely on the Trading with the Enemies Act at the time he did it, but later they were challenged in court, the tariffs, and in court, the government's argument was that a couple of different authorities, including the Trading with the Enemies Act, justified the tariffs. And the court in that case basically said, well, it doesn't say that the president can do this under the law, but it doesn't say he can't do it. So I'm going to interpret that as saying he can. That's just not how courts interpret laws today. So that's one issue. But also, if you look at the legislative history of IEPA, there was a real effort to constrain presidential authority so that it would be more circumscribed than under the Trading with the Enemies Act. So,
and then just finally on IEPA, to wrap this up, the what other emergency powers are unlocked when invoking IEPA?
well, as I said, it's mostly been used for economic sanctions, but it gives the president the power to regulate or prohibit or block, investigate, think there may be a couple of other verbs in there, but or compel, I think that's another one. So compel, regulate, prohibit, block, any sort of interest in any property in which a foreign person has any interest, any financial transactions in which a foreign person might have any interest that's under US jurisdiction. So, the way I summarized it earlier is that the president can freeze any asset, again, in which a foreign person would have some interest, or block any financial transaction. And the criterion of the foreign person having some interest in some ways is almost subsumed into the conclusion that that there is a foreign threat. So if the conclusion is that the activities of a person or an organization are, in some way benefiting a malign foreign actor, then that is going to lead to a conclusion that the foreign actor has some interest in the property of the person.
All right. That's Thank you for all of that on tariffs. I think it's just some in really important context that is missing from, unless you really get into the weeds of the coverage, but it's really just missing, and to me should be in like the first paragraph of every, anytime anyone writes about the president and the word tariffs. Let's just talk a little bit more about the Insurrection Act. And I'm trying not to be alarmist in these conversations, but I have to say the conversation I had with Damon Linker, which I hope people, if you haven't watched it, just watch that, and the sort of the intellectual history of this obsession with presidents invoking emergencies, and this line of thinkers that is very influential with a number of people in the administration, is just really worth paying attention to. Um, and the Insurrection Act is the one where, some people I trust who are not conspiracy theorists or super alarmist, but they, point to, a series of events that are not unlikely at all given current politics, and say, what, the Insurrection Act is the thing I fear the most. I don't mean me, but the people I'm paraphrasing here,
Yeah.
is the thing that they are worried about the most. And so I want you to just to sort of explain it, how it can be invoked, and then personally, what's your level of concern about that?
Yeah. Um, The Insurrection Act, as I mentioned earlier, it's the primary exception to the Posse Comitatus Act, which is the general rule that federal armed forces cannot engage in civilian law enforcement actions inside the United States. And the reason for that is really obvious, right? An army turned inward can very quickly become an instrument of tyranny. And we have seen that in countries all over the world for centuries. All you have to do is picture Tiananmen Square and those tanks sort of rolling into the square. Armies have been an instrument of oppression when presidents have used them internally. And so that is the risk. And so we've had this centuries-long tradition separating military and civilian government for that reason. There are other reasons too, right? So there is the threat to democracy and civil liberties, but there are more practical reasons as well, including the fact that soldiers are trained to fight and destroy an enemy. They are not trained as police officers, civilian law enforcement officers, who are supposed to sort of peaceably enforce the law while respecting people's constitutional rights, right? It is a very different training, culture, mindset. And if you take soldiers and you sort of throw them into this other setting with the very different sort of set of experiences and training that they have had, it poses serious risks to themselves as well as to the civilians with whom they are interacting. Not to mention the fact that our US armed forces are already stretched thin, performing their core mission of defending the United States against foreign adversaries. So pulling them away from that so they can serve as domestic police or border police um, doesn't make us safer. It makes us less safe. So there are many, many reasons why you don't want to see, as a general rule, the U.S. Armed Forces acting as a domestic police force. Of course, there have historically been situations where there is a crisis that is so that overwhelms civilian law enforcement, such that you kind of need to have the military step in. But I will say that you see less and less of that. And there are reasons why the Insurrection Act has not been invoked since 1992. And some of that is sort of political blowback and just our modern sensibilities.
Yeah.
But part of that is the fact that law enforcement itself, civilian law enforcement, has grown dramatically in its numbers, in its capacity, in the kind of equipment that it uses, which there's a
It's
lot of
become
military equipment
militarized.
that has found its way into yeah, exactly. And so, you look at a police force like the NYPD, which I think is something like 40,000 people. I mean, there just aren't that many crises that today's military is not, able to handle. So this is and should be, this is meant to be a very exceptional circumstance in which you would see the Insurrection Act used. But as I said before, we have this textual problem where the law is drafted in terms that might have made some sense in 1792 when the first version of it was enacted. And then it's been amended many times since then, but it hasn't been amended since 1874. So it is stuck in the past. Both the language it uses and the powers that it provides and the threats that they were facing at the time, right? Just a very different world that we're in today. So that is the problem we face with the Insurrection Act.
Just quickly, how was it invoked? And then you referred to 1992, which was George H.W. Bush invoked it.
1792.
I'm sorry, but
Oh, sorry, 19, yes. So in 1792 is when it was first passed. 1992 is when it was last used. Yeah.
yeah, it was last you said 1992, and that was during
Yeah.
the civil unrest in Los Angeles.
Yeah. Yep. After the acquittal of the police officers in the beating of Rodney King.
How how easily can the Insurrection Act be invoked? What triggers it? What's the law say?
Very easy.
Very
Yeah.
easy.
The president has to issue a proclamation. Yeah, he has to issue a proclamation, he or she has to issue a proclamation ordering people to disperse, to sort of give them a chance to disperse. And uh, that's pretty much it.
That's it. So if you have a messy protest here in Washington, D.C. at the White House or Congress or in any city, um, you could easily be in a situation where he can legally trigger that law.
Yeah, so in the original version of the law back in 1792, there had to be ex ante judicial approval. So a court had to sign off on it before deployment. And even then, there was a time limit on how long the president could rely on the Insurrection Act to enforce the law before Congress came in and approved it. So you had these checks from both of the other branches that were in place. Those were stripped out of the law. And they were stripped out mostly because the presidents were coloring within the lines. They were not abusing the law. They were following the process they were supposed to follow. And that gave Congress enough comfort and faith to get rid of these precautions. Now, of course, the fact that presidents were following the precautions when they were there isn't a great argument for getting rid of those precautions. So it was unfortunately sort of a misguided response to the way that the law was being applied by presidents. But yeah, there's right now there are no such checks by the judiciary or Congress built into the law.
All right, Liza, this is an incredibly important conversation, very unsettling in a lot of ways. And I just want you to sort of wrap things up with a general understanding of where Congress is on this. Is there any faction among traditional libertarian conservatives who you see as being interested or concerned about this in general, and specifically with what Trump has been doing? And then, what's your level of concern about these powers being invoked in an even more robust way by this president, given what you've seen in the last 100+ days?
Yeah, so you're raising an important point that we didn't really talk about, which is sort of how President Trump has used emergency powers thus far. He has declared 8 national emergencies in his first 100 days in office. That is a rate that far outpaces any previous president, including his own first term. And for the most part, I would say what we've seen in these particular declarations is a softer form of abuse. I mean, we already talked about the potential for these laws to be used in ways that undermine democracy and individual liberties, but these laws can also be used to implement policy preferences when the president doesn't have the necessary support in Congress, or when there's a law that would prevent him from doing what he wants to do otherwise. So there is a version of a misuse of emergency powers, and President Trump is not the only president to misuse emergency powers this way, to just try to get stuff done without Congress and to get around Congress. So we have seen that a lot since Trump's first administration. President Biden did it too, frankly, when he relied on emergency powers to forgive student loan debt.
Really
So
important
that
points. Yeah.
yeah. So that is the kind of mostly what we have seen so far. And the tariffs are a great example, right? I mean, that is an example of a policy preference, right? He wants to impose tariffs for policy reasons. Even though Republicans control both houses of Congress, he would have trouble getting that through Congress and getting it through the Senate, right? He would have a lot of trouble with that. So he's using emergency powers. Um, you know, Congress doesn't generally like it when the president, in such a kind of obvious way, kind of circumvents Congress through the use of emergency powers. And in fact, when Trump did it in 2019, when he declared a national emergency at the border to secure funding for the border wall, after Congress had repeatedly refused to give him the funding that he had requested, Republicans sponsored legislation to reform the National Emergencies Act. When there was a vote on the border wall declaration, 12 senators who were Republicans crossed over to the other side to vote to terminate the declaration. So historically, including recent history, Congress has responded. Has not been fond of presidents misusing emergency powers in order to circumvent the legislative body.
Oh,
Obviously, we are
we live in a
in
different world.
yeah, like it just even since last November, right? Things have changed, and so we are not yet seeing Congress standing up to these inappropriate uses of emergency powers. I don't think, I mean, we have in fact seen, Republicans actually signing on to bills to terminate tariffs. So it's not, not a lot, but a handful of Republicans have
Yeah.
been willing to sign on to resolutions to terminate the tariff emergency declarations. So that's the start, right? That's the
Yeah.
start. I think it's similar as it is with the courts, which is that as I said before, the courts will generally apply deference, but there is a scenario where to certain things, but there are scenarios where the president can overreach so badly that the courts will step in. I think we're kind of in a similar situation in Congress right now. There's a sort of a default presumption that conservatives in Congress are not going to stand up to this president, but I think that presumption can be overcome. And what we've seen in the past, the legislation that was introduced by Republicans by Senator Mike Lee of Utah was the lead sponsor in 2019 to reform the National Emergencies Act to give Congress more control over
Yeah.
emergency powers declarations, was incredibly popular on both sides of the aisle. To the point that last September, there were markups in committees in the House and the Senate. In the Senate, the bill passed out of committee on a vote of 13-1. And in the House, it passed by a unanimous voice vote. And that was during the campaign, right? So we don't see those kinds of bipartisan numbers for almost anything else
Yeah.
right now. People get it. Members of Congress get it. These are dangerous powers in the hands of presidents of either party.
Well,
Um,
I mean, to me,
yeah,
that's the part of this that is, with so many of Trump's actions that exceed the authority of previous presidents. That's the thing that is hard for me to wrap my head around is why in the world would Republicans who have generally been a little bit more skeptical of executive authority, or at least there was a robust strand of libertarianism in the Republican Party that was very, very skeptical of these powers. Why do they want to create these precedents that pick your they want AOC to have these powers in 4 years
when
if she
she's
runs for
president.
president? That's the thing
Um,
that boggles the mind.
yeah,
But you're much more optimistic about Republicans getting a spine on this stuff and reining him in. But you cite some good legislative history there to
right.
as a source of your optimism.
Yeah, absolutely. I mean, I've been working on this for years, and honestly, I've never seen an issue that had that kind of broad and deep bipartisan support, and very principled support as well. So, in a sense, I am optimistic because I think it is a question of when rather than if these reforms are passed. Having said that, the question when is a critical question, because a lot of damage can be done in the meantime. And at some point, if the abuses of emergency powers under the National Emergencies Act become more less about circumventing Congress on policy questions and more about consolidating power in ways that undermine rights and freedoms and undermine democracy. You know, we need Congress to stand up at that point. If they don't, we have a real problem. Um, and I would say that, the Alien Enemies Act invocation is a place where we've seen a war power. I don't know if you want to call it emergency power. It's certainly a war power.
Sure. Yeah.
Um, and we're seeing an abuse of that war power to enable the president to deport people without having to actually show. I mean, this is not a question of, whether or not you can deport people who are members of Trento or Raga. Of course you can, right? There's
Right.
plenty of authority in immigration law to do that. The question is whether you have to have some evidence that you actually show to someone, or whether we can just rely on the president's say so about who gets sent and imprisoned in a prison that's notorious for human rights abuses in El Salvador, right?
Yeah.
That is the question. That is a scenario where, it pains me because this is an abuse of executive authority in a way that should concern members of Congress. Um, I wish we were seeing more of that from conservatives in Congress.
Yeah.
Um, but
Well,
again, I am optimistic that we will see reforms. I get nervous when I think about the timeline.
Well, I don't share your optimism, but Liza, you have been working on this issue and warning people about this in both Republican and Democratic administrations for a long time. And, I'm sure it's one of those issues like climate change or anything else where the threat seems far off in the distance. And, with Congress, unless they see it, unless it's immediately in front of them, as you know, they don't always act. Um, but I want to tell people to, there's a lot more of your writing and testimony if people are interested in this issue. Liza is the senior director at the Liberty and National Security Program at the Brennan Center for Justice at NYU School of Law. Incredible resource for a lot of the issues we've been talking about in the last couple of weeks at Telos News. And Liza, thank you for doing this, for spending so much time breaking this down. I really appreciate it, and I apologize for all the tech issues we had early on today.
No worries. Thanks for having me.
All right, thanks everyone. Please subscribe if you haven't already at Telus News, and I'll see you all very, very soon. Thanks again, Liza.